we have is cause number 724-151-CR, Nathan Gene Collins versus the state. What says appellant?
Hillary Notardis for appellant Nathan Gene Collins, and I am ready to proceed.
And what says the state?
Carrie Sullivan for the state, we're ready to proceed.
Thank you. Ms. Notardis will have a 20-minute argument with a 5-minute rebuttal, and the state has 20 minutes.
I'm going to assume that this is in the right location for y'all to hear. Okay. May it please the court. Good afternoon. Thank you for hosting or allowing me to be part of this event here at Wayland Baptist. I participated in them at Texas Tech, but this is certainly a treat. So, at issue today and before the court is the issue of whether the Court of Criminal Appeals means what it has repeatedly said since 1992, that a deadly weapon finding in a criminal case is only appropriate when the weapon is used or exhibited during or facilitates the commission of a corollary or associated felony. In this case, appellant was charged and convicted of the offense of unlawful possession of a firearm by a felon. Prior to trial, after indictment, the state had filed its intent to seek a deadly weapon finding if upon a conviction. The trial court submitted a special issue with respect to the deadly weapon finding, and the jury returned an affirmative finding to that, and the judgment reflects that a deadly weapon, specifically a firearm, was used during the commission of this offense. The Court of Criminal Appeals has said since 1992, in a couple of cases that came down on the same day, Narin and Petty, that there has to be an associated, a deadly weapon finding has to attach to an associated felony. That is, the possession of a weapon alone is not sufficient for the court to enter a deadly weapon finding. And most recently, I think the most recent opinion, discussing the entire progeny, Narin and Petty progeny, is the Plummer case that was authored by Judge Cochran, and she provided a very good explanation of the expansion of deadly weapons and how deadly weapons can be used and authorized. And she also specifically listed some limitations that are not going to be permissible situations where a deadly weapon finding can be authorized. And specifically, she references a case called Patterson, and specifically says we have declined to uphold deadly weapon findings when the weapon was present but did not facilitate a separate felony. I think there's two bases of support for this argument. I think first and foremost, the case law, at least from the Court of Criminal Appeals, it has consistently said there has to be an associated felony. And the other issue is that legislative history suggests that the basis for deadly weapon findings expounds, and it gives us some indication of when and whether a deadly weapon finding is authorized. So specifically, and Judge Cochran talks about this in the Plummer case, she talks about, and she's talking about the precursor to today's deadly weapon finding, what we old practitioners are always going to call 3G offenses. And she talks about the subcommittee talking about the basis for allowing deadly weapon findings to be attached. And the intent, the purpose of the deadly weapon provision, which she recites, is to discourage and deter felons from taking and using deadly weapons with them as they commit crimes, not merely the possession of. And if the legislature had intended and courts had intended for the mere possession of a firearm, allowing it to be used as a deadly weapon, it certainly could have expressed that.
You mentioned Nairn and Petty. When I read those cases, they seem to say, yes, kind of what you're saying, hey, mere possession is not enough. You need an associated felony, unless the weapon was used in that crime. Here, we have a video, right? I mean, he's using the weapon. So why would we not fall out of that normal, I mean, he's using it?
Well, first, because I think the Court of Criminal Appeals has said, specifically has recited with approval Nairn, and specifically noted that in Nairn, the deleted deadly weapon finding, that the court deleted the deadly weapon finding because the short-barreled shotgun was both the subject of the conviction and the basis of the deadly weapon finding. It's it's not.
They weren't using it in Nairn, were they? It was just mere possession.
Well, I don't know. I don't know that there was. I don't know that that was fleshed out. I don't recall specifically the facts, but my recollection is in both Nairn and Petty that the issue was simply that's what they were charged with, and I don't believe the facts actually bore out whether the weapon was actually used in some way. My reading of that was that simply because the mere possession of it alone without an associated felony prevents or resulted in an unnecessary and illegal deadly weapon finding in that judgment. And I think sister courts, the courts of appeals, are actually divided on this issue. I am aware of, and I know that the state relies heavily on a 1998 unpublished opinion by Justice Dotson, where there was an individual who was charged with murder, and he was also charged with possession of a firearm by a felon. He was acquitted of the murder, and the trial court allowed and approved a deadly weapon finding with respect to the possession of a felon by a firearm, with the thinking being that we know he used this weapon because somebody's dead, whether or not, and that was a self-defense claim, so he was found not guilty by self-defense. And I am also aware of a more recent opinion that was authored by Justice Yarbrough, which you didn't actually address this particular issue, but in a concurring opinion, Justice Quinn actually said you do not have to have an associated felony. So, and in that case, he said if there's some evidence that it was used, then there can be an associated, then there can be a deadly weapon finding. Respectfully, I believe that that line is wrong, that line of cases is wrong. First and foremost, Tirado was a 1998 case, and after, Pett refused, but after that decision, there were a number of Court of Criminal Appeals opinions, most notably this Plummer case, where the Court of Criminal Appeals had the opportunity to say there can be a deadly weapon finding separate and apart from based on the mere possession, as long as there's some showing that they used it. They had the opportunity to do that, but they didn't, and specifically declined to hold that deadly weapon findings when the weapon was present but didn't facilitate a separate felony were inappropriate. in a dissenting opinion by Judge Clinton, obviously no precedential value, but he talked about double dipping. The gravamen of the offense of unlawful possession of a firearm by a felon is possession of a firearm by a felon. And that offense is complete when he possesses the weapon. If there is no other offense committed, there is nothing to which that deadly weapon can attach. That is, someone who is convicted of an offense where a deadly weapon, specifically a firearm per se deadly weapon, is an element of the offense and proven, to allow thereafter a deadly weapon finding is in effect double dipping on both the legislative intent for deadly weapons, but also the legislative intent for disenfranchising people who are convicted felons from being able to have a gun. The thinking being that it is separate and apart and a punishment in and of itself that you can't have a gun. The fact that the gun is used but not alleged as an offense by the state in a separate felony cannot be an additional punishment. As is, the state acknowledges that
This is the worst of the fact pattern. It's not just that he had possession of it, he also did use it.
he did use it.
I mean, it'd be closer if he just had it, because then it really would be double dipping, right? I mean, he just had mere possession.
Absolutely, but I don't think that the legislative history of the deadly weapon findings supports that being used, even if, or a deadly weapon attaching, even if the weapon was used, and as long as he's only charged with possessing it. I think the Court of Criminal Appeals has had cases to decide that issue and has chosen not to. There are a number of courts of appeals who have come down on the side of what we're asking this court to come down on, which is that there has to be an associated felony. That the Court of Criminal Appeals meant what it said when it said that a deadly weapon finding only attaches if there is an associated or collateral offense. And that's in keeping with the legislative history of the deadly weapon. Judge Cochran talks about, when she's detailing the legislative history of deadly weapon statute, she talks about the fact that the impetus for the deadly weapon is to prevent people from going to crimes and taking a firearm with them. That does not, so the gravamen of that, and the reason why we don't want firearms or deadly weapons to be used is because we don't want to exacerbate a situation that's already occurred. Here, the gravamen of the situation is that he is a felon and is not supposed to possess a firearm. Adding on an additional deadly weapon finding, I think, goes against the legislative history of the statute. And I also think it goes directly against what Judge Cochran talked about in Plummer, saying that there simply has to be an associated or collateral felony.
When was Plummer issued?
2013. There are a number of cases which I cited that stand for the proposition from other courts of appeals that, again, in situations where there's a possession of a weapon in a prohibited place, in order to establish a deadly weapon finding, the state has to prove that the weapon was used while committing a felony offense separate and distinct from the possession of the weapon offense. That's a Court of Appeals decision out of a 2007 decision from Beaumont called Comiskey. Texarkana, in a 2015 decision called Leslie, found the same thing, that the evidence must demonstrate that the deadly weapon was used or exhibited during the transaction from which the felony conviction was obtained. And so, in a situation such as this, and the state concedes, they could have charged an offense. They could have charged deadly conduct. And in that instance, I can see it totally appropriate for the trial court to submit a deadly weapon instruction and a special issue, and upon an affirmative finding to include that extra deadly weapon finding. That is not what this case is. The state relied entirely on possession of a firearm by a felon, and then attempted to bootstrap onto that the fact that the weapon was used. And I think, again, that that's double dipping, because the offense itself is complete once we have a felon who is known to have a firearm.
They don't have to be found guilty of the other felony. So for example, in your hypothetical, if they would have charged deadly conduct, you could have been found not guilty of that, but still the deadly weapon finding would have been okay because there's an associated felony.
I don't believe that to be true, actually.
Okay.
That was the situation with Gerardo, where they, in my opinion, Judge Dodson bootstrapped the testimony about the use of the weapon during the commission of a murder which was found to be self-defense, bootstrapped that onto a felony that no longer had an associated felony. The murder was gone, and so there was no conviction to which that deadly weapon could attach. So no, I don't believe that. If we had been in a different situation where deadly conduct had been charged and prosecuted, and that was found to be not true, I don't think that a deadly weapon finding would be allowable. This obviously is an important consideration, given the fact that 4212, the 3G, this deadly offense finding, has direct consequences for my client. So if he had not already been to the pen twice before, this would have been a case where he could have potentially been eligible for probation. Also, it is a situation where his sentence, his parole eligibility, is drastically affected by a deadly weapon finding. I simply think that the cases from the sister courts of appeals interpreting the Court of Criminal Appeals, using Judge Cochran's words, that a collateral offense or associated felony has to be there before, there's nothing to attach the deadly weapon finding to, unless there's a collateral offense or associated felony. Sorry.
Assuming Gerardo is wrong, do we only have the power to overrule that en banc?
That is an interesting question that I do not think I have the answer to right off the top of my head. But I would ask the court to allow me to do some additional briefing on that.
In the civil world, there's a case called Mitchie that says if we were to overrule prior precedent, it has to be en banc. I didn't know if that same will apply to criminal cases.
It happens so infrequently that thinking back, I can't think of a situation. My gut reaction is that it doesn't have to be en banc in a criminal case.
Well, possibly one way of looking at it is to say, if you can show that the Court of Criminal Appeals has changed the law since that time and implicitly overturned Jurado, then there would be nothing to overturn. We would just have
Right.
to follow it under vertical stare decisis
Right.
instead. But
Absolutely. Well,
that's something
and
we haven't addressed.
which is precisely why I note for the court that that's a 1998 decision, and we have had lots of case law since then that has gone contra. And so for all of those reasons, as well as the reasons we've discussed in our briefs, we would ask the court to find that there's insufficient evidence to support the deadly weapon finding, and ask the court perform the judgment to delete that finding.
Thank you. Mr. Sullivan?
Thank you, Justice Parker. May it please the court.
Mr. Sullivan?
Well, let me begin with this. The counsel has referenced a couple of times that, well, did the Court of Criminal Appeals mean what they said when they said there has to be an associated felony? And I know that in Ex parte Petty and Nerone, they came close to that. The context of those cases, there was no use of the deadly weapon. And there is language that would perhaps suggest that. But after Ex parte Petty and Nerone came Tyra v. State, which the state also relies on significantly, and which this court relied on in Jurado. And in Tyra v. State, the court stated, there is simply nothing in the phrase used a deadly weapon to imply that it must always be used to commit an associated offense. And the court went on to state that it's true that a deadly weapon is not necessarily used or exhibited when it's possessed. But I think the indication that it's not necessarily used when it's illegally possessed could indicate that, well, perhaps it was used, and if it was used, then the deadly weapon finding would be appropriate. And here, the deadly weapon was used with abundance by firing it 20 times across a highway and across 2 parks in Amarillo, Texas on the 4th of July. So in our view, the Court of Criminal Appeals' more recent precedent than those that established the requirement for the associated felony indicates very clearly and explicitly that no associated felony is required.
What do you think about Plummer? That's a 2013 case, so it's more recent certainly than Nerone and Petty and Tyra.
That is correct, Justice Doss. And again, in Plummer, the court was dealing with a situation where there was an associated felony. So that's the context of what they were writing. So they weren't dealing with a situation where there wasn't one. So they talk about associated felonies, and they talk about what level of usage is required for an associated felony. And when there is an associated felony, the court makes clear that the amount of usage is not perhaps as great. It doesn't have to be overt if it's in furtherance of an associated felony. And perhaps where there's no associated felony, you would require more overt use of the deadly weapon, but we've got that in abundance here. In addition, in Plummer, the court said that they granted review to decide whether the term exhibit in the deadly weapon statute requires that the deadly weapon must somehow facilitate or increase the risk of potential harm while committing the felony. And I think obviously the risk of potential harm was greatly increased when the appellant took the gun that he illegally possessed and fired it 20 times in celebration of the 4th of July. So we believe that, Plummer, again, was dealing with the associated felony, and so that's the focus of the case. but it does not revive the language of Nerone and Ex parte Petty that the court disapproved in Tyra. Plummer cites Tyra as well with no indication of disapproval. So I believe that that case is still good law. And so the issue here is straightforward. May a deadly weapon finding be made where the defendant is convicted of unlawful possession of a firearm by a felon and no other offense, if during that unlawful possession the defendant used the gun in a dangerous manner? We believe that the answer to that is yes, that this court correctly answered that question in Gerardo v. State. It is an unpublished opinion, but it's an opinion that faithfully follows the law, the statutory language, and the precedents of the Court of Criminal Appeals. The text of the deadly weapon statute provides that a deadly weapon finding may be used if a deadly weapon was used or exhibited during the commission of a felony. It doesn't talk about a separate associated felony. Based on that text, all felonies are at least theoretically susceptible to a deadly weapon finding, as the Court of Criminal Appeals has repeatedly found. And as they found, not with it being directly on point, but as they have also stated subsequent to Plummer, it's all felonies are potentially amenable to a deadly weapon finding. And this court has made that statement as well, at least one time. And so, if as the Court of Criminal Appeals has stated, all felonies are susceptible to that, this is a case where the possession finding would be appropriate for including the deadly weapon finding as well. Let me talk a moment, if I can, about the idea that the possession offense was complete at the time of possession. And if that's so, the next question is, well, how did firing the gun facilitate appellant's possession of it? Obviously, the possession was all that was required in order to show that the possession crime occurred. But the deadly weapon statute separately provides that the deadly weapon finding is appropriate if the firearm was used during the commission of that offense. So commission of the offense is the act of doing or perpetrating the offense. That's out of Blacks. The appellant...
Notardis was talking a while ago about the fact that you could have brought this as a deadly conduct case instead of as a possession case.
Or in addition. We could have done that. A deadly conduct case, as the trial attorneys tell me, has some challenges in terms of the proof and what evidence is required in terms of who was it fired in the direction of, what homes was it fired in the direction of, and here he was shooting indiscriminately across a highway and through the park. Sure, I think that should get them there, but there are challenges in terms of doing that. And the trial attorney concluded that she would move forward with this more straightforward case that was caught in living color on video, and there were the two prior felonies, so we knew what the punishment was going to be at a minimum. So that's some of the rationale for why we went that way and didn't include it. And we believed, we hope correctly, that the use of the deadly weapon caught here would warrant the deadly weapon finding, even for a possession offense. But if I could get back to the language in terms of the requiring that the deadly weapon be used during the commission of the offense. The commission of the offense is that act of doing or perpetrating the crime. Appellant was committing the offense of unlawful possession at all points in time that he unlawfully possessed the firearm. So it's true that, you know, he unlawfully possessed it right at the beginning of when he possessed it, but it's also true that he unlawfully possessed it right at the very time that he was firing it indiscriminately in the backyard. So it was occurring during the commission of that offense. And the state would also respectfully submit that the purpose that counsel identified of the deadly weapon finding, that we don't want criminals to go carry their deadly weapons with them as they go about doing their crimes, that purpose is satisfied with an affirmative finding here. Better for a felon to unlawfully possess a firearm safely locked up at home than to take it out and shoot it indiscriminately to celebrate the 4th of July. So, you know, we believe that that's satisfied. So, again, this court in Gerardo followed the precedent of Tyra as laid out by the Court of Criminal Appeals, concluded that the statute simply doesn't require an associated felony, and concluded that in that case the defendant used the deadly weapon, obviously by killing an individual, in what the jury determined was self-defense. Likewise here, the defendant abundantly used the deadly weapon while he unlawfully possessed it. So we believe that Gerardo is good law, and that this court should uphold its precedent. We also believe that Plummer does not change the law in a way that would, if Plummer does not overrule Tyra, which this court relied on. And so I do believe that Gerardo is good precedent, and it's directly on point. So whether, I also realize this court has at least discussed the idea of horizontal stare decisis in a couple of your opinions on attorney's fees where they've been deleted, and you all have made those findings with respect to that. So, and hopefully not beating a dead horse, but an analogy with respect to the possession requirement, and is it completed? Is that crime done at the time of possession? Might be an illegal possession of drugs case. And in Patterson versus State, the court dealt with a situation where there was unlawfully possessed illegal drugs, methamphetamines, and an unlawfully possessed firearm by a felon. And the court concluded that, you know, with the associated felony, the firearm, even though it wasn't actively used, well, it was there and available, and so was assisted or facilitated the possession felony. Well, there's no question in the decision, not that it came up, that, well, the possession of did the possession of the drugs happen before the possession of the firearm? The possession of the drugs, you know, we don't know which came first, the drugs or the gun, but it shouldn't matter. The possession of the drugs was an ongoing crime for the duration of the period that they were possessed. The possession of the firearm was an ongoing crime for the possession of the period that it was possessed. And we know that they overlapped at some point, and so there was no thought that the possession of the drugs was completed at the initial time that the drugs were possessed. Just like we would suggest here, there's no completion of the unlawful possession of a firearm by a felon at the very beginning of that offense. It continues on during the duration of that unlawful possession, and the defendant here used the gun in the manner captured on video, and that the jury found appropriate to add the deadly weapon finding. And I think I've run out of things, so do you all have any additional questions that I could address? Thank you, folks.
Thank you.
Just briefly, Your Honors, the Court of Criminal Appeals could have said that and Judge Cochran certainly could have said disapprovingly of Naren and Petty that those offenses should not have been subject to a deadly weapon finding, but she did not. When she spoke about all of these, the cases, both expanding the deadly weapon, the use of a deadly weapon finding, and those limitations on the use of the deadly weapon finding, she discusses all of these. There are many, many, many cases that she discusses, and routinely says, we will not extend deadly weapon findings to offenses where there is no associated felony. And so while I understand the danger of shooting a firearm in a city, I'm certainly not going to dispute that. But if the state had wanted to have the opportunity to have such dire consequences on my client's parole eligibility, then they should have filed a case that would have allowed them to attach that deadly weapon finding. There is no evidence, no legislative evidence, no case law evidence to suggest that that there was any desire to allow an individual who is a convicted felon, who's been disenfranchised and cannot possess a gun, to then additionally have a deadly weapon finding. And Judge Cochran, and again, I rely heavily on Cochran because I think she definitively says there has to be an associated felony when she didn't have to. And I think that her discussion of the legislative history also supports the fact that certainly we don't want people going out and committing felon offenses with firearms. But there has to be an offense that they're attempting to commit with a firearm separate and apart from possessing the firearm. And so it's our position that the deadly weapon finding was improper. It should not have been submitted to the jury, and that the judge's inclusion of an affirmative deadly weapon finding was improper, and the court should delete that.
Thank you, counsel. This will conclude our argument. The case is submitted, and we certainly appreciate Wayland Baptist for hosting us today, and to the members of the Hale County Bar Association for lunch. We enjoyed that, and we will do recess. Thank you.
All rise.